Hi, I'm Anna Denton-Jones, and in this second week of Knowledge November, I'm going to focus on constructive dismissal. We've been talking about people having changes forced upon them and their right to resign and claim if that happens to them. Now, actually, it would be claims plural because potentially they'd claim for the notice pay and benefits arising from the constructive wrongful dismissal or breach of contract angle. They'd also, if they've got more than 2 years service, claim constructive unfair dismissal using the unfair dismissal legislation. Compensation for unfair dismissal is calculated in two ways. The first part, the basic award, very similar to statutory redundancy pay, based on somebody's age and their length of service in a week's pay, up to a maximum of just over £19,000 for a long server who was in their 60s. And compensatory award, generally a year's salary, but up to £105,707 for your higher earners. Average awards actually are nowhere near those figures. Average awards, I think, are around the £12,000 mark still. So it shows that people aren't rewarded for staying at home and watching daytime telly. They're actually awarded for their financial losses. So obviously, if they go off and they get another job, perhaps the amount that they can claim is curtailed because of that. So when we talk about a constructive dismissal, what we have to establish is a fundamental breach of contract. And I like to think of this as the sort of Marks and Spencers of breaches of contract. It's not any old breach of contract. It's the, highfalutin, repudiatory, we call it, fundamental breach of contract that we're looking for. It's quite easy to establish that in the sort of change of contract arena, where we're talking about pay and benefits. So anything that's going to reduce pay and benefits to somebody, it's very easy for them to persuade a judge that that is a fundamental breach of contract, particularly in these difficult times of cost of living crisis. Anything that involves them moving potentially could be a breach of contract if not enough notice is given. So if somebody's just told they got to move, that's probably going to be a fundamental breach. We could have a fundamental breach arising from a breach of the implied term of trust and confidence. So where we've got behaviour of the employer breaching that, or where there's been a series of smaller breaches that perhaps aren't fundamental but get us to a sort of last straw kind of argument, then that may get us over the hurdle. The next ingredient that's going to have to be there is that the employee hasn't accepted the breach. So the amount of time until they've resigned from when the change was imposed is going to be relevant. So, for example, there was a case in the 90s where some employees waited a year after a change had happened to bring their complaint. That is not going to surprise you when I tell you that they weren't successful. They were found to have affirmed or agreed to the change by not flagging it up as an issue for that long. So employees who want to work under protest have to really make that clear. Otherwise, they're at risk of losing their rights to bring claims. If you've got any questions, please do let me know. It's ADENTON at Refreshing Law Ltd, the shortened form of limited.co.uk. Thanks.